There are actually a couple of things that I wanted to talk about this morning, and I spoke to a couple of folks on the way in, and everybody has a question about what's going on around the country with regard to constitutional protection of pension benefits. So I want to start with that because I know that's on the minds of folks. Here in Texas, the Texas Supreme Court, in a case earlier this year involving the Houston municipal employees, actually had an opportunity to interpret Article 16, Section 66, which is the constitutional protection provision of the Texas Constitution. It has never been directly interpreted by an appeals court in Texas. There's a trial court that interpreted it unfavorably to, in the district court level, unfavorably to the Fort Worth board. That decision was not appealed, so it's just a trial court decision. Two federal judges in Fort Worth involving two cases, one involving two firefighters, one involving two police officers, two different judges, both disagreed with the Attorney General, who had issued a very comprehensive opinion back in 2008 in response to a letter from Representative Phil King that said, that got to the real heart of the issue. There's no disagreement that once you're retired, nobody can adversely affect your benefits with subsequent legislation. No one so far has looked backwards to undo what somebody already earned, even if the change goes forward. The Constitution speaks to vested benefits because it says you have to be a person who doesn't have to render any more service in order to be eligible to receive a benefit. And if you have a plan that has a 5-year vesting provision in it, you can work your 5 years. You might not be eligible to begin drawing, but you have, in essence, earned all of the time necessary to get a retirement, and when the right birthday rolls around, you show up and get your check. The real crux of the issue in Texas is, what about someone who's vested, and the law changes, and it has to do with future service, meaning service earned from the day of the change till the day you're retired? I mean, it's our view that the Constitution was specifically intended to protect that person, that if an ordinance or a statute was changed looking forward, that if you were already vested, it wouldn't apply to you. It would apply to new hires and non-vested people. That's what the courts have disagreed with so far. The Attorney General saw it the other way. And both of the Fort Worth federal cases are on appeal. And the police case went first, and the initial briefing has already been filed. And in that initial brief, there is a request to certify the following question to the Texas Supreme Court. In the case of a vested employee, does the Constitution preserve the benefit formula for a vested individual as it relates to future service to the date of retirement? And Texas has a statute that allows the Supreme Court to receive questions from federal appeals courts. And the only federal appeals courts that would be sending things to the Texas Supreme Court is the United States Court of Appeals for the Fifth Circuit, which is located in New Orleans. The other court is the Supreme Court of the United States. Many states allow a federal trial court to certify the question. Texas's statute specifically does not allow a trial court, but it does allow a federal court. So what's the answer? I still think I'm right, but we'll find out. It's going to be about a year till we know the answer to that. We'll know fairly shortly whether the court's going to certify the question. The federal court can also decide the question itself. But what's interesting is when a federal court decides a question of state law, unless it's the Supreme Court of the United States, it's not binding on the state courts in that state. So if the U.S. Court of Appeals were to affirm the decision, meaning uphold the decision, it would affect those 4 employees in Fort Worth, but it wouldn't affect anybody else because they were not class actions. And it would not be binding on the Supreme Court of Texas. The only court that can bind the Supreme Court of Texas is the Supreme Court of the United States. Otherwise, the Texas Supreme Court is the sole judge of the law of the state. So we'll find out in fairly short order. Elsewhere around the country, New Jersey has one of the worst funded pension systems in the country. And there's really a fairly simple reason for it. They don't put any money in. They first determined that they had a funding issue in 1919. They had a study done by a legislative committee, and if you think about it, everybody who was on the committee is dead, and they're actually right. They were actually right that they were going to run out of money early in the 21st century. The state of New Jersey has put in about 19% of the actuarially required contributions since 1919. I'm shocked they're actually still able to pay benefits. The unions in New Jersey sued last year over an issue involving funding. In New Jersey, they said you have a constitutional right to the benefit. No one's ever disagreed with that. But they say there's no constitutional right to the money. In other words, you can't force the legislature to appropriate money. Now, the current governor, he's running for re-election, or actually he's running for election for something else. He and his wife, I think, are the only ones who think he's going to win, and one of those two people's a little shaky. And I'm not sure which one. In any event, he made a deal with the legislature that said, I'm going to solve the pension crisis in New Jersey. We're going to have a stair-step funding over 7 years to make up the gap, and we're going to pay our full actuarially required contribution every year going forward. First 2 years, they actually made the payment. Comes year 3, which was the fiscal 2013-14 year, they spent all the money on something else. And then it got to the end of the fiscal year, they declared an emergency. The union sued, and the court said, look, I can't manufacture money out of air. The legislature appropriated the money for the 14-15 year and added a tax on millionaires, which they said would provide exactly the revenue needed to pay this extra stair-step payment. And the governor vetoed the appropriation, and he vetoed the tax. And the unions sued again, and actually the pension funds, which are my clients, have also filed a lawsuit seeking funding. We're still in trial. We haven't even got to the trial, but we did appear as a friend of the court in the union suit. And in the union suit, they said, okay, we're here in plenty of time. We're here before the fiscal year even starts. We want the money. Trial court issued a 111-page decision and saying why they had to fund it. The bottom line of it was, she said, the state stood up during argument in court and said, we promise we're going to pay it. We're good for the money. It took her 110 pages, but she said, I don't believe you. You've been saying that since 1919 and you haven't got it right yet, so why should we start now? It went directly to the New Jersey Supreme Court because she really directed what she actually did was ordered the governor and the legislature to figure out where within the budget they're going to find the money to make this payment. She didn't order the legislature to appropriate the money. She said, out of the money you have appropriated, you've got to take however many millions it was, hundreds of millions, and actually it was 1.6 billion. Take the 1.6 billion, and I don't care where you get it from out of your $40 billion budget, just go find it and stick it in the pension fund. One of the things that actually came out during the course of that argument, the Supreme Court normally holds, when state Supreme Courts hold arguments, each side usually gets 20 minutes. When you go to the Supreme Court of the United States, you get 30 minutes for each side. The New Jersey Supreme Court gave this case 3 hours. It's the only time I've ever been to an appellate argument where they took a bathroom break. And given the age of the lawyers, thank God. So as a friend of the court, you usually don't get oral argument at all. They gave us 20 minutes. And the bottom line to the court was, if you don't do something, we're going to run out of money. The judicial retirement system is actually the worst funded, which usually gets their attention. In this case, it did not. The judicial retirement system's maybe got 12 years left at the current rate of payment. And unless the market hits some enormous home run and stretches it out a few more years, they will literally be insolvent. They will have to make the payments to retired judges on a pay-as-you-go basis, meaning the legislature will simply have to figure out what the amount of payments is that year and just appropriate it like a salary appropriation. The police and fire fund is actually better funded because 90% of the people that are in it are city and county employees. Their part of the fund is over 90% funded because the cities and counties have always made their required contributions. The dilemma is, for the people who are state employees, if the state side runs out of money, are we supposed to dip into the city-county side to start paying the state's debt? And the answer is no. That was a question we were asked, and I said, we can't take other people's money and spend it. The cases continue. What the pension funds are seeking now is a judgment, which we're going to try to enforce in the same way all other judgments are enforced. You have to get in line for an appropriation, and hopefully the legislature will appropriate the money. But as long as the current governor is in office, quite frankly, their solution is just veto the bill. Hopefully I can get another job before the pension fund runs out of money, and they know where I live. So that's what's going on. Illinois, which has the worst funded state system in the country, as you may know, the Supreme Court of Illinois said the attempt to lower benefits for current workers and retirees violated the Illinois Constitution. Very close language to what's in the Texas Constitution. The difference is in Illinois, the constitutional protection applies on day one. It doesn't need to wait till you're vested. So to that extent, it's broader. The Supreme Court wrote a very lengthy opinion and undid all of the legislation. A trial court in Chicago, using that decision, rendered a similar decision with regard to attempts to lower benefits going forward in the Chicago retirement system. Arizona, they lowered benefits for justices of the Supreme Court and other appellate court judges by trying to eliminate the COLA. The Supreme Court of Arizona, shockingly, said, no, judges' pensions are important, and unanimously struck down the attempt to lower the benefit. That case was interesting because it was the pension fund that actually advocated for the change. They said, look, we're underfunded. You got to do something. Our most expensive benefit is the cost of living adjustment, because even though it's not paid till years after someone retires, you got to start funding it on the first day. So it's pretty expensive. For them, it was almost 11% of payroll to do a 3% COLA. The California, there's a ballot initiative. In fact, I've got a CalPERS meeting this afternoon by phone where they're going to be discussing that. There is an initiative which they're seeking to get signatures for, sponsored by the mayor of San Jose, who unsuccessfully tried to change the pensions for his employees. And even though he was successful at the polls, California court struck it down. The idea is to close all defined benefit systems in California going forward. Anybody who's in one stays in one. All new people would go into a defined contribution plan. The Attorney General is required to prepare the ballot language. She just issued it a couple of days ago, and it basically says, this is what's going to happen. No one will have disability. Police and fire, if they get injured or killed in the line of duty, will have nothing. And by the way, it's going to raise your taxes for 25 years. That's the Reader's Digest version of the ballot summary. Of course, the people who want to push this initiative are not happy about it, and I think they want to legally challenge the ballot language, which will forestall it ending up in front of the voters for some time. California tried the exact same thing 10 years ago. All the actuarial studies showed it would cost a bundle of money to do this. Cincinnati cut benefits to its city workers. Public safety are in a state system. Teachers are in another state system. City workers are in their own system. City had poor funding discipline, but they had an overfunded retiree health care program. And interestingly enough, while they have constitutional protection for the pension benefits, they have no protection for health care. So they were going to do away with the health care benefits. The employees sued. We settled the case. It's actually the settlement is up for approval in front of a federal judge next month. It'll restore about 90% of the benefit reductions and preserve the health care benefit. Other cases that are going on around the country, there's a Florida Supreme Court case that's awaiting a decision that arose out of collective bargaining. Also has to do with an employer's ability to unilaterally reduce retirement benefits. It was argued in April. The Supreme Court went on vacation, had not ruled before they went on their summer break. They return in a week. We'll find out soon enough. So all of this is continuing around the country, and I want to now can lead into an ethics question. What happens if the reason a plan is underfunded was poor decision-making by the trustees? The New Orleans firefighters is a relatively small system because it's a fairly small fire department. The size of it hasn't grown in years, but they got a lot of older members. And so as the mortality rates have gone further out in age, the cost of the plan has risen. Had they made a series of private equity investments and direct ownership of real estate investments in the mid-2000s, and when the market crashed in 2008, so did the investments. And it resulted in an increase in the city contribution, an unexpected increase of $26 million. The city said, we shouldn't have to pay that. It ain't our fault, it's their fault. They were dumb, and so therefore the taxpayer shouldn't be set upon. Supreme Court of Louisiana said, that's not what the Constitution says. It says it's your problem to fund it. Good idea, bad idea, wise move, unwise move, you have to contribute. So then, the chief fiscal officer of the city, who sits as a trustee of the fire fund, says, well, you know, as a fiduciary, I have a responsibility to address this poor conduct by my fellow trustees. So he sued them all individually on behalf of the other members of the fund and says, even though the city's got to put in the $26 million, I think you all have to put up money too for your failure as good fiduciaries. The trustees said, no, we have sovereign immunity, set that forth as a defense. Trial court dismissed the case. The same Supreme Court of Louisiana said, you got to fund the plan. Said, not so fast. They said, maybe you do have liability if you departed from the standard of care that's applicable to a prudent trustee, and reinstated the lawsuit. So it'll be interesting to see what happens there. When speaking about ethics, as you know, the state ethics code does not apply to municipal plans in Texas. There was a recent change to the local government code, and the changes are described in the materials which I provided for you, and I understand everybody passed the reading test yesterday, so I won't read it to you. Basically, you can't do business with your brother-in-law, you can't take something that's worth more than $100, and if you do, don't tell anybody. That seems to be the change in the law. Okay, you're supposed to report it, but the essence is that there's better reporting, a broader range of who you really cannot do business with without conflicting. Your ethical responsibility is if someone's doing business with the fund, you need to know what their connection is to anybody who's in a decision-making position. Whether it's the staff of the fund or whether it's a trustee, you have a duty to get these disclosures and a duty to ensure that there's not a conflict of interest. I'm going to give you an example of what might be, and you'll tell me if you think this is an ethical problem. You're the executive director of a large pension fund, and you're being paid almost $1 million a year, and a former trustee comes to you and says, I really want you to hire this manager, and if you do, I will give you $250,000 in unmarked $100 bills in a shoebox. Now, how many think that that's okay? Well, that's good. You just passed the ethics test. That actually happened. The former director of the California Public Employees Retirement System accepted over $200,000 in paper bags and a shoebox from a former board member who got tens of millions in fees as a result of this arrangement. The former board member was actually scheduled to go on trial, but after the executive director pled guilty to accepting a bribe and is probably going to go to jail for about 10 years, he took his own life rather than face the music. Let me give you another ethical example. You're the city treasurer, and you sit on two of the city's two pension boards. You really like the finer things in life, but you don't get paid to get the finer things in life. And so someone says, oh, please, it would be my pleasure to hold a party to honor you for your service, and instead of a plaque, we're going to give you a sack full of cash. We're also going to give you a ride on private jets. Oh, and that plastic surgery that your special friend wanted, well, we'll fix her up on that one too. And if while she's busy recuperating, oh yes, we have some special hostesses who'd like to meet you. And they're highly skilled professionals. And if you think that's okay, hold up your hand. Well, that's good. You're batting 1,000. That's what happened in Detroit. The former city treasurer accepted bribes from asset managers who are now serving long terms in prison. He was convicted of accepting the bribes, and he's facing 25 years, I think. I think he's eligible for parole when he's 71, 72. The former general counsel of the fund, who'd been the lawyer there for 40 years, is the one who facilitated the party planning. He was also convicted, but died about a month ago while awaiting sentencing. The former mayor, who introduced everybody, is serving his 3rd prison term for a variety of stuff. Oh, by the way, if your government is paying for your cell phone, everything that's on it's a public record, don't send love notes that you don't want anybody to read. They are public records. The newspaper will read them. Suppose you're the governor of a state whose initials are New Jersey. And you'd like to run for, let's say, president. And so you're responsible for appointing members of the State Investment Board. and you have a tremendous amount of influence over that process. Does anyone think it's an ethical problem if your major contributors seem to be the ones that get most of the investment business, have the lowest rates of return, and charge the highest fees? Does anybody see an ethical problem there? I hope everybody does. But that's exactly what's under investigation now in New Jersey. The New Mexico Supreme Court just issued a ruling about 3 weeks ago reinstating a lawsuit about pay-to-play there, where the former governor engaged in similar activities where if you wanted to get state investment money, state money to invest, you had to be you had to be in the special club where you donated, all for campaign contributions. That lawsuit had been dismissed, it's been reinstated, and a lot of people are looking at issues. There were people who were fined large sums of money. The former governor made an unsuccessful attempt to run for president and is likely out of the picture. But, and the initials of that state are New Mexico. So another current candidate for president was the governor of a familiar state to me, and he's had relatives who lived in the White House before, so he thought he, just wanted to go home. And he was accused at the time he was governor 15 years ago of also directing business to friends. That has, of course, although nothing came of it at the time, and they did change their State Board of Investment changed its investment policies, the issue has rearisen because of Jeb Bush's candidacy for president. So the bottom line is you need to be very careful about access. Now a serious comment. While the state ethics code, which would prohibit all of this stuff, doesn't apply to you, it's actually a serious crime in Texas to either use your public office for personal gain or to accept bribes. I know that may come as a shock, but it's a serious felony, and because of the kind of the gap in enforcement at the municipal level, I would not be surprised to see prosecutors leaning more towards looking at chapters 36 and 39 of the criminal code, which is the felony statutes for misuse of office and for bribe taken, to use that as a tool for enforcement, whereas the State Ethics Commission has less onerous penalties available to it. You may remember a story involving the trustees of the San Diego City Pension Fund from some years ago. Not really that long ago. Case just ended really in 2012. The city went to the Board of Trustees and said, listen, we know we're behind on payments. We'd like to establish a payment plan for you, and we want you to look at what the actuarial impact would be of this payment plan. The board looks at the actuarial report, and it called for essentially stair-step funding and a big balloon payment at the end, which I got to tell you, balloon payments are not a good, they never get made. They always get refinanced, and that's a problem. But in this case, the board adopted the actuarial report, which supported this agreement really between management and labor. When the time came to pay the balloon payment off, the economy had soured, and the city had overspent on some things like stadiums, and so went back to the board and said, we have a new payment plan that we've worked out with labor, which is going to increase benefits, and we want you to approve the actuarial study. Board looks at it. Again, it called for another mortgage, and it incorporated the old mortgage into the new mortgage. The board adopted it. Then comes the market crash, and everybody gets upset because now it has really tanked the system. And so the local district attorney says, well, it's obviously the Board of Trustees' fault. And the elected members, meaning those elected by the membership, are all indicted for violation of the state ethics law because they said, well, hell, the benefits increased. Now, these were 7 of the 13 trustees, and they were the people who were also members of the retirement system. They said, well, you got a benefit. And they said, well, we didn't pass it. The city council passed the benefit change. We just approved the valuation, which was how much it cost. It was sure looked like a dumb idea, but they just wanted us to validate it. Our actuary looked at it and said the numbers were correctly calculated and they could make the payment or maybe not. It went all the way to the Supreme Court of California when ultimately the Supreme Court said it wasn't their fault. They adopted the valuation, and the reason they got charged was because of a reason the court couldn't come up with. They said if anybody should have been charged, it was the city council for approving the deal. But at the same time, the trustees are getting sprung at the state court level. They were indicted for federal crimes of theft of honest services. And the statute they used to charge them with were 2. Some people got the actuarial valuation mailed to them. So the trustees were charged with mail fraud. Some of them had it sent electronically, and so they were charged with wire fraud. And conspiracy to do both. That's where you plan to mail something, and then you take an overt act like putting a stamp on the envelope, and if somebody actually sticks it in the mailbox, they're criminals. The federal court, after the state Supreme Court decision, said the ethics code really wasn't intended to do this, that they were in the same class of everybody else. It's no different than when the state legislature changes a law regarding a state retirement system and they are just one of a group of people that gets the benefit. If the benefit was for a specific person, and there have been ethics cases where a board adopted, say, a rate of return on drop, and the only people in it happen to be the people who are on the Board of Trustees, that would be to your personal advantage. If you adopt a valuation which applies to the plan as a whole, and then the plan sponsor adopts a benefit increase, you don't have the legislative control because you're all executives in a sense. You're all part of the executive branch of the government as trustees and administrators. Secondly, it's not a personal gain if you are no different than the greater class of people who are participants in the plan. And essentially, it's almost like a rule of necessity that somebody's got to run the place. And by serving on the board, I don't think it was intended that you not benefit from this. So what's the best thing that a board can do? If you don't have an ethics policy locally, you really ought to have one. Number one, it helps manage your relationships with the people who do business with the system. When you come here to TexPERS, is this because there are corporate sponsors who some of you do business? Is that somehow taking something? The answer is no. I think it's pretty clear from the state law that if you are attending an educational conference and the events are open to everybody, it's not a problem. Is it okay to have a meal with people? Yes, but they should be there. Do not accept gifts. I mean, we've had situations where Trustees have accepted tickets to expensive events. They've accepted trips. They've accepted things of great individual financial value. And most of those people are called prisoners now. And, ethics really isn't rocket science. It's really, if you have to pause to think about, should I do this? You already got the answer. The answer is, don't do that. It's like when I was a kid, I learned a lesson. I have an older brother. And I used to watch, and he used to always ask for permission. And then when the answer was no, there'd be a big fight. Now, I didn't ask for permission. I always thought forgiveness was easier to come by. In the ethics world, but of course you have to be prepared to take the beating if you do get caught. I was taller when I was a kid. The beatings wear you down after a while. But the point here is that if you're a trustee, forgiveness is not easier to come by. If you think you have to ask for permission to do this, you already have the answer. The answer is no. And it's important when you do adopt an ethics policy that if someone is pitching business to you, it's really best to limit your contact outside of the meetings during this romancing process that goes on. Because two things really come from it. One, it suggests that you're for sale, which I don't think you are. Now, as a personal matter, I don't think anybody ever got bought for a hamburger or a, glass of scotch. If you are, you're easy, but too easy, and you shouldn't be a trustee. But more importantly, it casts doubt on the contracting phase. And the contracting phase is really as important as the selection. You want to go through the due diligence, which trustees have to do. And let me tell you about a failure of due diligence. And this is, I know nobody would ever do this. This is a true story. City of Minneapolis used to have a fund, a pension fund for firefighters and a pension fund for police officers. They have since been merged into the state system. All local employees are in one of two pension plans now in Minnesota. But when they were still an active fund, the governor came to them and said, because they were the largest of the independent funds, they said, listen, business is terrible in the Iron Range, which is where they used to mine iron in Minnesota. They said, we've got someone who we think can really develop the area, bring 1,000 jobs to a depressed area in Minnesota, and you'll get a good rate of return on your money. It's a winner for everybody. So the first people to do the due diligence was the police board of trustees. So they invite the guy in, the governor's friend, or his recommended business partner. And so they asked him, they said, where are you from? He says, oh, I'm from St. Paul, Minnesota, right across the river, the other twin city. And so that was the end of their due diligence. They said, well, his people are from Minnesota. He must be okay. And they gave him $35 million. Now, the firefighters met the next week, and their due diligence was, well, the cops checked him out, and they gave him the money, so he must be okay. The guy did everything with the money, but build what he was supposed to build. It was a complete loss. They all lost their dough. The members sued the boards because the loss of the investment income actually affected the payment of a certain cost of living benefit based on excess earnings, and because they both had a whopper hit from this, and their insurance companies paid off to solve the lawsuit. The lesson in that was it's not impolite to ask questions. It's not impolite to say, have you ever been sued for breach of fiduciary duty? You need to ask that question. It's not impolite to say, is the Securities and Exchange Commission investigating you? It's not impolite to say, have you ever been in prison? When my daughters, who are now all married, were first looking to date, I told the first boy that came, I said, well, son, I'm willing to go back to prison, if you understand. And he said, what do you mean back to prison? I said, well, they said it was a murder. I said it was an accident. But that kid didn't talk to me for a month. But I didn't like the kid, so good riddance to that boy. Anyway, the point is, it's okay if you're a father testing out your daughter's dates to talk about prison. It ain't okay if anybody's ever had an issue. And if you don't have a rigorous due diligence process, or if you have compromised your integrity in the search process, by even creating the appearance of impropriety, you've really failed as a fiduciary, because the problem most assuredly will come back to haunt you. It limits your ability to be a tough negotiator when it comes to these contract issues. And I think you want to know, is anybody suing you now? And I don't care if they're getting sued because they ran over somebody with the company, lunch truck, but I want to know if they're getting sued for fraud or negligence or breach of fiduciary duty. These are the things you want to know, and you can't be a prudent fiduciary yourself if you've allowed yourself to be compromised. I've known a lot of people in this room for 25 plus years. I knew Max when he had hair. So the point is that although you can have friendships in the business, you still have to maintain a business relationship separate from the friendship. And if the friendship gets compromised financially, then I think that's a problem. So you need to be scrupulous. And if you don't have a written policy about this, you'll be inconsistent in your behavior. And I think that's one of the other things that causes pension funds the biggest problem, boards of trustees, is inconsistency in the way in which you run your business. And you ought to be consistent about limiting your contact when you're dating them, and you need to limit the type of contact you have after you hire them. Because while you have to judge them fairly on the way in, you also got to judge the performance fairly. I mean, sometimes things go bad in investments. Sometimes they just don't work out. But you don't want to be like those guys in Minnesota. It didn't work out because they didn't do their job. They befriended this guy. They accepted his hospitality when they shouldn't have, and in a fashion that they shouldn't have. And they ended up getting sued over it, and there was a lot of aggravation and a loss to the fund. So the last thing that I want to talk about, and then I'd really like to take questions because I know there are some, is because I got a lot of them on the way in. And here's what Max always tells me. He says, encourage them to ask questions, and here's what he told me to say. He said, in the room, they're free. Out in the hall, they cost money. So Max says he wants everybody to get the free questions. So, and since when am I getting paid for coming here? I never knew. My kids probably got it. Anyway, the last point that I want to make on all of this is you can't panic. Investments do go badly. One of the things that some of the larger state systems are dealing with right now is risk mitigation, which is just a fancy word for their taking a more conservative approach in their investments. And to do that, obviously, they've got to lower the assumed rate of return because of the results that happened in 2008 when some of them were way out on the more exotic investment scale, and those were the victims of the market collapse. And so they're starting to lower, and the question is, well, we're going to take it on the chin from the employers by raising their contribution. And in many states, plan redesign is actually requiring a split between workers and the employers when the normal cost of the plan rises, which will happen if the assumed rate of return goes down. Then everybody's contributions are going to go up, and there's pressure on the trustees. You can't listen to the noise. I admire the work that all of you do, and I've worked with a lot of you, and I know you're all people of integrity. And the important thing is there's going to be bad press, there's going to be complaints from members, there's going to be complaints from plan sponsors. But what really matters is, did I engage in a thoughtful approach to the problem? And if you did, don't worry about the noise. You can't, can you get sued? In Texas, it's really hard. If you exercised careful discretion, you literally are virtually immune from the consequences of your decisions. When you judge the value from a fiduciary standpoint, when you judge the effect of an unfortunate investment return, it's not judged by what happened at the end. It's judged by the knowledge that you had at the time you authorized the decision. When you hired that manager, it's what did you know about that manager at that time? If you show that you made that your decision making was a result of cautious study and review, you got professionals in to assist you, such as investment consultants or managers who explained the process to you of either the sector of the market that you were going in or why they were the right person in that sector, then your decision making is immune. Things do go badly, but they only go badly if you failed at the beginning. The bad isn't at the end. And as always, Max, it's a pleasure to be here, and I'd like to got about 10 minutes left to answer some questions. Pete Morin.
Wait for the mic.
And his meeting is Wednesday, so he's getting in a quick one.
Which he charges for.
Yeah, I will. In fact, I'm thinking about it right now.
I know.
That's 2 hours. Okay, what's your next question? Seriously, Pete.
All right, so Bob, we enjoy constitutional protection for our pensions that the citizens of Texas obviously voted and approved. I think it'd be helpful for us to understand going forward what the process would be if some rogue governor or lieutenant governor decided, you know what, that constitutional protection is not good for the citizens of Texas. What would they have to do to overturn it?
You know, the Constitution is the ultimate expression of the will of the people. It's the one limit on the legislature because the people empower the legislature to do what they do. In my view, when the electors adopted this provision in 2003, they said the legislature, and by implication cities and counties, taxing districts, cannot do the same, cannot cut benefits for people who are vested. In order to change it, it would obviously be subject to a repeal, but the repeal could not undo the rights that vested in the people at that time. So even if that provision were removed by the electors from the Constitution, then anybody who had received its protection due to the length of their service, I think would remain protected throughout their careers, but anybody coming behind them who was not yet vested or not yet hired, they'd have no protection going forward. It would be as if it never existed as to them, but to those who have it, I don't think you could take it away. It's property. Your ownership of your pension rights is a species of property, and the Constitution says you can't take away property without due process. Oh, I'm sorry. It would require the same, either the legislature would have to adopt it and place it on the ballot, or it would require an initiative, which whatever the requisite number of signatures is to put an item on the ballot, and it would have to be approved by the electors in order for it to occur. But even that process could not undo the property that you had acquired while that provision was in effect, in my view. Now, as I said, there's already been, 2 federal judges who didn't see it the way I saw it. The Attorney General saw it, who's now governor, by the way, saw it the way that I see it. Until the Texas Supreme Court settles the question, we'll all be in a state of uncertainty.
So, Bob, pension systems are created by statute. So are the bargaining agreements and meet and confer laws that we have on the books.
Yep.
So what are your thoughts when you have one versus the other, where you have bargaining or meet and confer that are making changes in pensions, and if you run into a headbutting contest, which one trumps the other?
Well, the meet and confer and collective bargaining statute says to the extent that a collective bargaining agreement conflicts with a statute, the collective bargaining agreement or the meet and confer agreement controls. So you have to try to harmonize statutes, and you say, well, isn't that kind of in conflict with something else? I do not believe that that could be used to take away constitutional protections of individuals. That issue has not been addressed in Texas. It's actually the jurisprudence, meaning the court decisions, are very undeveloped in terms of the bargaining laws because it's relatively new. That's exactly the issue that's awaiting a decision in the Supreme Court of Florida, where a city, the city of Miami, used a statute which says if a city's got a financially urgent situation, it can demand some accelerated period of bargaining. At the end of that, just take away the benefits. And the argument was by the unions that that takes away the constitutional rights of participants. Two appeals courts, meaning mid-level appeals courts like the appeals courts in Texas, I think there's 14 of them or something here, conflicted in their decisions. So the Supreme Court agreed to settle the dispute. That case has been briefed and argued. I'll let you know when the decision comes out. While it obviously wouldn't be binding in Texas, those types of cases have been instructive. There is some jurisprudence in New York which has a similar pension provision that says the union could give away rights of people that it bargains for on a forward-looking basis, even though that would seem to conflict with the New York State Constitution. That case did not go to New York's High Court. Their Supreme Court, their highest court is called the Court of Appeals. That was a lower-level appellate court decision involving only one bargaining unit in one place. There's a U.S. Supreme Court that a union can give away certain rights of members. It has never been decided in the context of a pension. That's really an open question. It's my view that once you vest in these particular provisions, that notwithstanding the collective nature of the bargaining relationship, which means one union deals with one employer and everybody, that's the deal for everybody, because there's a constitutional provision that gives rights to individuals, it says a person gets this constitutional right to the benefit. I don't think the majoritarian process of collective bargaining, which I'm not smart enough for that word, but that's what the case law talks about, I don't think can take that individual right away. It can take away procedural rights. Can't take away, in my view, this property right. But I will tell you, the courts have been much less protective, or the protection for pensions has been very uneven. I mean, Illinois went one way, Arizona went the same way, Colorado said, COLAs are not really part of the pension, and took those away. Trial courts in Minnesota and South Dakota said the same thing. California was protective, but that's strictly by case law, not by their constitution. So who knows? I mean, the answer is it's an open question. It puts trustees in a tough place because what are you supposed to do? Which one do you follow?
So it's my understanding that in the Chicago case with the mayor, where he's basically tried to crawfish out of the benefits, i.e. I think it was the health care that were negotiated by bargaining many moons ago. Mm-hmm. And if I understood them correctly when I was up there, the decision that basically came down from the state Supreme Court that says, you guys are right, you win, is basically trumping what the mayor was trying to do, and they basically told him, sorry, you lose. Is that your understanding?
Yes. There's another case pending in the Illinois Supreme Court involving the transit authority employees. There's like 10,000 transit authority workers, and here's what happened. The union actually bargained a reduction in retiree health care, which in Illinois, their courts have said has the same protection. It's a pension benefit, they've said. And the union gave it away, lowered the deductibles and raised the contributions and the co-payments, and in some cases did away with it altogether. A group of workers who had, one group had vested, another group had retired. The Supreme Court, or actually a middle-level appellate court in Illinois, said the retirees get to keep it. Even though they were still working, they were eligible to retire, you couldn't invade their benefit with the collective bargaining agreement because we're not going to punish them because even though they've crossed the finish line, they can, they're still working, union can't take that right away. For the ones that are still working, even though they're vested, the union has that power to give it away. Both sides appealed. The Illinois Supreme Court said it would settle the question. That case was argued and it hasn't been decided. That's going to be a really definitive, in my view, hopefully, decision as to what are the limits of bargaining as it relates to the individual rights that someone is granted under a state constitutional provision. In Michigan, which has a pretty good constitutional provision, so the unions can give away vested rights. You know, a lot of people are worried about bankruptcy, and Texas does allow municipal bankruptcy. I think that's a really minor issue. Most cities are solvent. Detroit made a deal which involved a reduction in benefits because the alternative was worse. And actually the folks voted on it. There's still some fighting going on. There's still some challenges to the plan of adjustment in Detroit, but that was an extraordinary circumstance that no city in Texas finds itself in.